This video is about the penalties for drink driving offences here in New South Wales. Now, I don't want anything that I say in this video to be taken as anyway condoning or diminishing the consequences of drink driving. Drink driving is a very serious criminal offence. It creates catastrophic consequences for road users and their families. A lot of people die due to drink driving, and again, I don't want this video to be seen as diminishing the impact of drink driving on our society. Now, the first category of drink driving offence that I'm going to talk about is called low range drink driving. Now, the penalty for low range drink driving, if it's the first major traffic offence within 5 years, is this. There is what's called an automatic period of disqualification. Now, an automatic period of disqualification is what the court, the magistrate, will give you unless there are reasons to reduce it down to what's called a minimum period of disqualification. Now, the automatic period of disqualification for low range drink driving is 6 months. Now, the magistrate can reduce that down to a minimum period of disqualification of 3 months. There is also a maximum fine of $1,100. Now, that's for low range drink driving, first major traffic offence within 5 years. If it's your second or subsequent, so second or later major traffic offence within 5 years, then the automatic period of disqualification goes up to 12 months. The minimum period of disqualification goes up to 6 months. So, if the magistrate finds good reasons to reduce the automatic period down to the minimum period, the magistrate can reduce it from 12 months to 6 months. Now, what are good reasons? Good reasons can be a good driving history, a strong need for a licence, a person who otherwise has no criminal convictions, who has produced character references, who's done the traffic offender program. Things like that can reduce your automatic period of disqualification down to the minimum. The second level of drink driving offences is called middle range drink driving, or mid-range PCA. Now, for a first major traffic offence within a 5-year period, the automatic period of disqualification is 12 months. The minimum period of disqualification is 6 months, and there's a maximum fine of $2,200. It also attracts a maximum prison sentence of 9 months. So it's a serious offence, and it can give you prison time, so you have to treat it quite seriously. Now, if it's your second or subsequent or second or later major traffic offence within 5 years, the automatic period of disqualification is 3 years, and that can go down to a minimum of 12 months. There's also a maximum fine of $3,300 and a potentially 12-month prison sentence. Now, the final category of drink driving offences I'm going to talk about is the very serious offence of high-range drink driving. Now, for a high-range drink driving offence, high-range PCA offence, for a first major traffic offence within 5 years, there's an automatic period of disqualification of 3 years, and the magistrate can reduce that period of disqualification down to a minimum of 12 months. It attracts a maximum fine of $3,300 and a possible prison sentence of 18 months. Now, for a second or subsequent major traffic offence within a 5-year period, the automatic period of disqualification goes up to 5 years, and it can be brought down to a minimum period of disqualification of 2 years. There's also a maximum fine of $5,500, and it attracts a possible jail sentence of 2 years. So you must treat it very, very seriously. Now, for all of these categories of offences, the magistrate, or the judge as the case may be, can deal with you under what's called Section 10. Now, Section 10 means that you're guilty of an offence, that is, you've entered a plea of guilty or you've been found guilty, but the magistrate or judge does not give you a criminal conviction, does not give you a disqualification, does not give you a fine. However, you will only get a Section 10 if there are good reasons to do so. So, good reasons could include a good traffic history, so you've been driving a long time, have had very few speeding offences or no speeding offences or anything of the sort. You can get together character references to support your position in court, or to help your lawyers support their position in court. You can do a letter of apology, that is, a letter apologising for your conduct, accepting responsibility for your conduct, and communicating to the magistrate or the judge how you feel about this. You're understanding that there could have been catastrophic consequences of your actions on the night. Another thing that you can do, and it's very, very important, is to consider doing a traffic offender program. Now, traffic offender programs are programs that last usually 6 or 8 weeks. However, there are intensive programs that can go for a weekend or 2 weekends. Now, the 6 to 8 week ones run 1 night a week, so you may go there for 2 hours. And at the end of the traffic offender program, the convener will fax a letter to the court saying you've done this program, you understand the consequences of drink driving and things that can support you in your case and to help you get the minimum period of disqualification or a section 10. Now, if you'd like a free first appointment with an experienced traffic lawyer here at Sydney Criminal Lawyers, you can call us 24/7 on 9261 881, and we offer fixed fees for all drink driving cases. Those fixed fees are published on our website. Also on our website are a letter of apology guide and also a guide for doing character references. There's also a list of available traffic offender programs. Hope to see you soon.